Oh yay, oh yay, oh yay, this Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
All right, good morning, everyone, and welcome. We're pleased to have you with us today. We have 3 cases on the morning docket. We will call them in the order in which they appear. Please recall that the appellants and the appellees each have a total of 15 minutes, and that applies even if there are multiple appellants or multiple appellees in a case. And if they are, you have to share that 15 minutes. The appellants have the option of reserving up to 5 minutes for rebuttal. And if you wish to do that, please state how much you wish to reserve when you get to the podium and after you've just introduced yourself. Are there any announcements or introductions? Hearing none, call the first case, please.
Michael Gersper versus Jonathan Turner.
Good morning. Good. Oh, you're welcome to proceed.
May it please the court. Good morning, Your Honors. I'm Sarah Martin, and I, along with my co-counsel Jamie Holland, represent the defendant and appellant in this case, Mr. Jonathan Turner. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes, certainly. And if I may, before you start, and this applies to both sides, in reading the briefs, I believe that there were occasions where plaintiff and defendant were interposed, and it was quite confusing. So I would rather you say Gersper and Turner instead of plaintiff and defendant, especially when you have a petitioner, and it gets confusing. So
sure.
If you choose to do it the other way, you may, but it'll just confuse me, and you might lose me.
I'll do my best, Your Honor.
All right, thank you.
This is a strategic lawsuit against public participation, or a SLAP, the very kind that the Tennessee Public Participation Act, or the TPPA, was enacted to address and deter. The court should reverse the decision of the trial court for 2 reasons. First, the facts the plaintiff has pleaded, Mr. Gersper has pleaded, cannot even conceivably form the basis of a malicious prosecution claim as a matter of law. And second, courts must adjudicate pending claims for affirmative relief under the TPPA despite a plaintiff's non-suit in order to effectuate the legislative intent of the act. I'd like to first go over just the pertinent facts that are applicable here. Plaintiff, Mr. Gersper and Mr. Turner were both owners of the Bernie Dillon. Mr. Gersper is a realtor and has had listings in the Benny Dillon. Plaintiff made a video of the Benny Dillon, which is at issue in Mr. Turner's complaint, where he pointed out nonstop construction at 6:30 in the morning, a constantly beeping call box, a fire alarm panel that appeared to be non-working, water damage, and at the end sarcastically exclaimed, "I'm sure you want to buy this condo, great idea." That video is linked on page 22 of the record in footnote 1. Mr. Turner received the video from multiple owners in the building per his declaration in the record at page 45. Mr. Turner then consulted a realtor.
You say Mr. Turner received multiple videos from multiple people in the building?
The video that Mr. Gersper filmed was sent to Mr. Turner by multiple other owners in the building.
I thought Mr. Turner refused to testify as to how he received the video.
He didn't refuse to testify as to how
Did he identify anybody?
He didn't identify anyone specific in his declaration.
So then how do we know?
In his declaration, his testimony is that he received it from multiple people. Those people were not identified.
But when asked whom, he said he wouldn't identify them.
Not exactly, Your Honor.
Did he identify anybody?
He did not, but he was not asked to before the trial court. There was no hearing where he testified, if that's what you're asking. Okay. It was just a declaration that was submitted with his petition. Mr. Turner then consulted a realtor who told him that the video raised ethical concerns. Then he filed a written complaint about the video. He attached the video to the email, and then he stated several opinions about the video to the Tennessee Real Estate Commission, which is considered a judicial body. And then plaintiff then brought this lawsuit for malicious prosecution. After Mr. Turner filed his TPPA petition, the plaintiff non-suited all of his claims except for malicious prosecution. So the defamation and false light claim and the tortious interference claims were non-suited.
So is it fair to say that the questions concerning this appeal can only pertain to the anti-SLAPP petition, right?
Yes, Your Honor.
Okay, and that can only pertain to the malicious prosecution claim, is that correct?
Under this court's jurisprudence and Solomon and Flade, yes.
Thank you.
Of course, we're arguing for a change in the law.
Yeah, but right, but
yes.
Sometimes for me, when the people are throwing mud all over the wall, I'm trying to figure out where should I be looking, and thank you. Okay.
Yes, Your Honor.
What do we do, or what does a trial court do when it's faced with two bases for dismissal, a motion to dismiss for failure to state a claim and a TPPA petition?
Your Honor, as Mr. Turner has briefed, when Mr. Turner filed his TPPA petition in the trial court, he incorporated by reference all of his same arguments in the motion that were in the motion to dismiss. So Mr. Turner would ask this court to look at the face of the complaint and the fact that there were that the allegations were insufficient to establish a claim as a matter of law, and still grant the TPPA petition as to that argument.
So you would say the court should have to do both then?
Yes.
If faced with a motion to dismiss for failure to state a claim and a TPPA petition to dismiss, the court, is it in that order? Do they do motion to dismiss for failure to state a claim first and say, okay, I think it should be dismissed on that basis, plus now I'm going to say there's no basis here for a claim, and TPPA also applies. So you do both in that case.
Yes, Your Honor.
And so what tells us, I mean, what in the statute indicates that should happen that way?
So under the TPPA, which is a remedial statute that is designed to encourage and safeguard protected First Amendment activity under Section 102 of the statute, it sets forth a specific framework. And the framework is that the defendant has the initial burden of making a prima facie case that the legal action is in response to First Amendment activity, the right to free speech, the right to petition, the right to association. And then the court shall dismiss the legal action unless the plaintiff establishes a prima facie case for each essential element of the claim in that legal action. And then separately, the court shall dismiss if the defendant comes forth with a valid affirmative defense. And then if the court dismisses the plaintiff's claims, of course, the defendant is entitled to attorney's fees and costs and possibly sanctions. So Mr. Turner's position is that the plaintiff, Mr. Gersper, cannot possibly bring forth prima facie evidence of his claims that he pleaded in his complaint because the complaint doesn't contain facts to support certain elements of the malicious prosecution claim. So, for instance, and just to sort of clear up whether the TPPA applies, because Mr. Gersper has argued that it shouldn't. This was an exercise of the right of free speech, which is defined as a communication in connection with a matter of public concern. Matter of public concern is defined in the TPPA as including things like economic issues or property value, and services in the marketplace like realty services. So in Mr. Turner's brief, he's alleged that there was no prosecution. So for instance, there has to be a prior suit or judicial proceeding that was instituted and finally determined on the merits in the plaintiff's favor, and it has to be brought through malice and without probable cause.
And I'm guessing in a lot of the Supreme Court's recent decision, no action on the complaint really doesn't fall within that framework, does it?
It does not. So to start, there's no factual basis on the face of the complaint to conclude that any investigation took place, much less formal proceedings. Rather, Mr. Gersper's complaint merely states that after being reviewed by legal staff and presented to the commission, the complaint was, quote, closed with no action. So even if such proceedings had taken place, providing information to a governmental body that is responsible for determining whether to move forward with proceedings cannot rise to the level of malicious prosecution, and that's from this court in Weichel and Cohen. Cohen in particular is very clear that there has to be prosecution brought. And there's no evidence that that happened here per the face of the plaintiff's complaint. Mr. Gersper has argued that that's not the case when it comes to intentionally false allegations, but Mr. Turner did not make intentionally false allegations. He sent a video and then he opined on it. The commission was free to view that video for itself and make a determination.
So as an appellate court in a case like this, let's say on your issue 1, malicious prosecution, to get to Judge Clement's question about what's before us, do we really look at all then at the motion to dismiss for failure to state claim and just focus on the TPPA petition in this appeal? I mean, we may agree with you that it doesn't state a claim here based on the fact that there's no allegation of a favorable termination on the merits, but we really cannot get to that, can we? Because we're just reviewing the TPPA portion of that, or am I wrong about that analysis?
Well, Your Honor, it would make sense that under the framework of the TPPA, because the TPPA says you have to bring forth prima facie evidence of each element of the claim, and if you haven't pleaded sufficiently an element of the claim, then it makes sense that you shouldn't really be able to bring forth evidence that you for a factor that you didn't plead. Yeah. So even though typically a denial of a motion to dismiss is not appealable, all of those arguments were incorporated by reference into the TPPA petition.
It all gets mixed up together. I guess we would address it, but not really get to the merits of it because it's wrapped up, you're saying, in the TPPA petition. Okay, let's get to your issue number 2, and you wanting me to backtrack on Solomon against Solomon. Sorry about the timing on that.
Yeah.
But our court appears to be unanimous on the concept that no vested interest, not a statute, is contemplated by Rule 41. Where we are divergent on is this a counterclaim for purposes of Rule 41 relief? Where does Solomon get it wrong? And I will not take any offense, Ms. Barton. I know you'll do a good job telling me where I got it wrong.
Thank you, Your Honor. I appreciate that.
And why Judge Clement should have never concurred.
I was misled.
Yeah.
I know lawyers are bad at math, but I can count to 2, and I know my odds here. So the court in Solomon and Flade and Adamson, yes, agreed on the first 2 arguments that were made, and then kind of diverged from Adamson. The court in Flade was very adamant that the language regarding the counterclaim was just dicta in Adamson. But dicta has a very specific definition, and the Supreme Court in Staten said that a statement can only be dictum if it has no bearing on the direct root or decision of the case. The Adamson plaintiff explicitly raised the counterclaim issue, and then the court held that because the TPPA provides a substantive remedy and a TPPA petition asked for affirmative relief, it would survive a non-suit as long as it was pleaded prior to service of the non-suit. And so that's what happened here. So Mr. Turner's position is that the courts in Solomon and Flade should have followed that guidance from Adamson. And just generally, if pending TPPA petitions do not survive a non-suit, then plaintiffs who file baseless claims to teach others a lesson can parachute out of a case as soon as it looks like they might actually be held accountable for their misbehavior, and everyone loses. The Tennessee General Assembly, whose legislative intent in enacting the TPPA has been obliterated, the represented defendants who are left with tens of thousands of dollars in attorney's fees and costs, the pro se defendants who can't afford to self-censor, and the willing listeners who want to hear what those people have to say.
Yeah, I get that, but you do get in part what you're asking for. You get a dismissal, and it seems like to me we want to encourage plaintiffs to see the error of their ways early in the case and say, oh, wait a minute, I made a mistake here. And you don't even have the situation like you had in Solomon, where what they did was they ran to federal court then and filed the case up there so they could avoid the TPPA. But you do get the dismissal, and that seems to be a beneficial and serves the end of the TPPA, does it not?
I see I'm out of time. May I answer
Yes,
his question?
certainly.
So it kind of boils down to Section 102 of the Act, which very explicitly states its purpose, and then the very last sentence of it says it should be broadly interpreted to effectuate the Act's intent. And here, if you're broadly interpreting the Act to effectuate its intent, the only conclusion can be, hey, the legislature intended for these people to be able to get representation and then intended for them to be able to recoup those costs. So if a plaintiff's goal is to shut someone up, then they have achieved that goal by chilling the marketplace so that these folks can't get attorneys on, a contingency basis. They have caused pro se defendants to just merely say, I take it back, please don't sue me. And that does not appear to be the intent of the Act, Your Honor.
All right, thank you.
Thank
We'll
you.
hear from you on rebuttal. We'll hear from the appellee. Good morning.
Good morning. May it please the court, Kurt Clements for the appellee and plaintiff, Michael Gersper. We would respectfully submit that the trial court's denial of the TPPA petition should be affirmed for three basic reasons. First, the defendant failed to establish a prima facie case that the TPPA is applicable in this matter. Plaintiff established a prima facie case of malicious prosecution. And number three, pursuant to
Well, let's stop there with
Yes,
the
Your Honor.
malicious prosecution. The Real Estate Commission took no action, and I hope I can find that. The decision has been made to close the complaint with no action. How does that result in a favorable determination on the merits for your client?
Your Honor, I would respectfully submit that that is a ruling on the merits because Mr. Turner submitted the video, he submitted his complaint, which included argument as to why Mr. Gersper had violated the applicable statutes. And sent the video. So the commission had the benefit of Mr. Turner's position and the video. In turn, Mr. Gersper filed a response. He submitted an argument as to why he was not guilty or should not be censured. Apparently, according to this letter, the commission considered it, and they closed the complaint and took no action. And I would respectfully submit that you don't have to have an actual trial to resolve.
No, you don't have to have a trial, but the judicial body or the quasi-judicial body is supposed to make a decision on the merits, and simply saying, we're not going to take any action. How does that evidence a decision on the merits?
Well, keep in mind the context here, Your Honor. They sent the video. The video is everything. You can't dispute what's in it. It's very apparent.
Yes, but what the Supreme
Yes,
Court
Your
has told us in Minot is that you've got to be able to determine from the documents that it's on the merits.
Yeah.
And you're saying, look at the context here. We can't do that. We have to be able to say, from the documentation, can we determine that this disposition was on the merits and showed the innocence of the accused? Now, that's the criminal, but it would
Right.
be the equivalent for the civil side of it. When a commission takes no action, we don't know that. We don't know why no action was taken.
Well,
Can we presume that public officials are supposed to do their duty, and if the commission had seen wrongdoing, they would have taken action, and by not taking any action, that is in fact a finding of no wrongdoing?
Yes, I mean, that's my position. This is a finding of no wrongdoing. They had the video, they had argument from my client. They could look at it. And first and foremost, it had nothing to do with my client, Mr. Gersper's license. He was submitting this video as an HOA board member. So you don't need to have a hearing to determine that this had nothing to do with his license and dismiss it immediately. Furthermore, the video demonstrates conclusively that the video was not false. Mr. Turner accused Mr. Gersper of fraudulent misrepresentation, dishonest statement, fraudulent statements. The video demonstrates that everything that he said about the building was true. Mr. Turner doesn't even try to dispute that in his declaration. He doesn't say, well, it wasn't true that the fire alarm goes off constantly. He doesn't say the party room, the roof in the party room is about to collapse. He does nothing to dispute the facts found in the video because he can't. They are all true. So I think it's a very simple conclusion. It's not a logical leap at all that the board looked at this video and said, A, this was not sent under the purview of Mr. Gersper's license. It was sent for other reasons, and that there was no fraudulent misrepresentation within the video. I guess the other side of the coin is, how can they say that it's a favorable determination for Mr. Turner? It certainly is not. And I don't think it's analogous to a case being retired in a criminal case. That is a dismissal without merits. It's a settlement. You've decided that you'll plead guilty and then the case will ultimately be retired, or whatever I don't know the exact settlement terms, but it's not the same, it's not analogous at all to this case. There was no discussion, there was no agreement to retire it. It was a simple dismissal. It was an effective dismissal of his complaint. And so I would respectfully submit that it is a favorable result for Mr. Turner. I also would point out, I don't believe that was argued by Mr. Turner at the trial court level or even in their initial brief. I tried to find that argument and I could not. And so if I'm correct about that, they've waived that issue. I believe that, you know, as Ms. Martin indicated, they concede that the Real Estate Commission is a judicial body. Their only argument as to that element was that, from my memory, was that Mr. Turner did not prosecute the claim. He just gave information, which is inaccurate. If you read his complaint, he's not just giving information. He says, even though you don't want my opinion, here it is. And he goes into a diatribe as to why Mr. Gersper violated all these statutes. That's my memory of what the defendant's argument was as to that element. As to the other elements, well, first let me address the whether or not the TPPA applies here. Importantly, 20-17-1033 of the TPPA says, an exercise of free speech is defined as a communication made in connection with a matter of public concern that falls within the protection of the United States Constitution or the Tennessee Constitution. Intentionally false statements or intentional false statements are not protected by the Constitution. That has been well established since New York v. Sullivan. As I just went over, this complaint was an intentional false statement. It is not afforded any protection under the TPPA. And I also would submit, if the court finds that Mr. Gersper's real estate license was not implicated here, this is not a matter of public concern. It's a private matter between a private citizen about a private building. Mr. Turner wanted it to make it about his license, but the undisputed facts are that he didn't submit this. He didn't take this video.
So
as
are
a real
you
estate-
saying all complaints to the commission would not be covered, or just this one?
Just this one. I think there is an argument that had it truly implicated his license, that the TPPA could be applicable here.
So, and that goes to the prima facie showing that the petitioner has to make, that this is
Yes, Your
that,
Honor.
okay. But they never got to that stage of the proceeding, or I guess the court made the determination, I mean, how far did the court get in making that analysis? Was there actually a holding that this was a prima facie showing or not a prima facie showing that it's covered by the statute?
No, the court did not state that explicitly. In fact, I was just looking at the order. I believe the last sentence says this motion is denied. It doesn't say motions or petition.
Yeah, I mean,
It
it
just
just
says
seems like the
motion.
court was focusing on the failure to state a claim component of it.
That is certainly
So
a
on-
reasonable interpretation.
So on this record, do we get to that issue, or, I mean, it seems like to me we may have to send it back just for analysis of whether or not the prima facie showing, or what you're saying is that on this record, we can make our own determination.
Yeah, I mean, I would submit that he certainly didn't grant the petition and dismiss my client's cause of action. So the logical conclusion is that when he said motion, he was referring in general to both the motion to dismiss and the petition. So I would respectfully submit that that's properly before this court to make a ruling as to whether or not the TPPA is applicable, or my client's cause of action should be dismissed pursuant to the TPPA.
And so how would you address my question about the order of precedence here when you have a motion to dismiss for failure to state a claim and a TPPA petition to dismiss? What order does the court take those, and why? Why does it take it in a particular order?
Yeah, I was confused as to why both motions were filed. First of all, I mean, if you're filing the TPPA, then
Well, isn't that what a good defense attorney does, is they
Well-
file whatever defensive motion they think might work?
well, I mean, it certainly wasn't unreasonable to do it, but I guess the court could take a look at both motions and say, oh, well, you survived the TPPA petition, but you don't survive the motion to dismiss. I mean, I guess that they could say that the TPPA is not applicable, but yet the motion to dismiss is.
So does it matter then what order the court takes of them? I mean, I guess you would get potential for attorney's fees in both instances if you're successful on either a motion or petition,
They filed it.
although there's a limit under one and doesn't appear to be a limit under the other, as I recall.
Correct.
So does it matter?
I really don't have an answer for that, Your Honor, to be honest with you, because in this case, the court appears to have taken, as you read his rationale, he undertook both motions. He did an analysis.
Although we don't know for sure what basis the TPPA petition was denied on.
Not, I mean, I think there is a
Or I guess
reasonable
we could-
interpretation that he determined that my client did make a prima facie case of malicious prosecution, and therefore the TPPA petition was dismissed.
Okay.
Or not
So-
granted.
Okay, well, by that statement, it presumes then that the defendant, then Mr. Turner, did make his prima facie showing, because your prima facie showing doesn't, or your showing doesn't trigger until he's made a prima
Correct.
facie showing that it's covered by the statute, so,
That is the implication.
okay.
If the court interprets the order that way. going through the rest of the elements of a malicious prosecution cause of action, just quickly, the elements are: a prior suit or judicial proceeding was instituted without probable cause. Defendant brought such prior action with malice, and the prior action was finally terminated in plaintiff's favor. We've touched on 1 and 3, but going to whether or not, or let's go to the element of without probable cause. Probable cause is established when facts and circumstances are sufficient to lead an ordinarily prudent person to believe the accused was guilty of the crime charged. Of course, here it's not a crime, but he's accusing Mr. Gersper of violating a statute related to realtor's conduct. And when you look at Mr. Turner's complaint and you compare it to TCA 62-13-104, which addresses the conduct of realtors, you can see that basically what Mr. Turner did was he took that statute and went down it by each element and then made his own allegations. So if we look at the language of 62-13-104, Roman numeral 1 says, making any substantial and willful misrepresentation. Mr. Turner says in his complaint, making willful representations, pretty self-explanatory. Roman numeral 3, pursuing a continued and flagrant course of misrepresentation. He makes the argument flagrant misrepresentation of making false statements and advertising them via video, and then he addresses other portions of that statute. But he did not have probable cause to make any of those allegations for the reasons we've already discussed. Mr. Gersper did not submit this as a realtor, and the video shows that nothing he said within the video was false. So then when we get to malice, there's actually now a presumption, if you don't find a probable cause, that he acted with malice. And I would respectfully submit the timing of this complaint, which was 5 months after he first got the video, but 9 days after he was not allowed to run again for the HOA board, which my client was an important part of that decision. When you look at that timing, it's clear that that was his motivation for filing this complaint against Mr. Gersper.
All right, thank you, Mr.
Thank you, Your
Clements. All right, thank you, sir. Ms. Martin, your rebuttal. And as you come forward, I'll ask the question, was the issue raised in the trial court concerning whether there was a favorable decision on the merits concerning the complaint before the Real Estate Commission?
Your Honor, broadly, yes. That whole element is about a final decision on the merits that, the judicial proceeding that occurred had to terminate on the merits in favor of the plaintiff. As a threshold issue, there was no judicial proceeding. When Minot came down, which of course wasn't out at the time, this was litigated in the trial court, of course, that made it abundantly clear that a situation like this, where you have an independent decision by a prosecutor, here the Real Estate Commission, and you have information provided to that prosecutor, and it's their decision, and they just decide to do nothing and not bring any proceeding, then that's just more evidence that there was no termination on the merits to this matter. So broadly, it was just asserted that there was no prosecution, nothing ever occurred. And then on appeal, Mr. Turner went further because the Minot decision had come down.
So your position is that someone can file something so poorly in an administrative to an administrative board that the board looks at it, says, well, there's nothing here, we're not going to take any action, and that's not enough to file any sort of malicious prosecution because it was just done so poorly?
Under Minot, that's correct, Your Honor. You asked if the court can make these assumptions that the commission, by not doing anything, did terminate the proceedings that didn't happen on the merits in favor of the plaintiff. The answer to your question is no. The Supreme Court has said in Minat, quote, "A plaintiff can pursue a claim for malicious prosecution only if an objective examination limited to the documents disposing of the proceeding or the applicable procedural rules indicates the termination of the underlying proceeding reflects on the merits of the case and was due to the innocence of the accused." So the court's not allowed to make assumptions.
So we can't determine whether it was just so poorly pled that it was no good, or the board actually decided that there was innocence, so it can't be a merits determination.
Well, let's make it analogous to Minat. So in Minat, there was a prosecution brought, the informant was the union, and then the prosecutor brought this action and then retired the charges. Retiring the charges is not a settlement. It's kind of unique to Tennessee law, as I understand it as a civil lawyer, in that, and I'm about to run out of time if I may finish answering Judge's question. So when a prosecutor retires the charges, it's more like, you know, they could have decided that they just don't want to spend their prosecution resources on that case. It could be because they have a problem with evidence. They think a witness isn't credible. That doesn't mean the person's innocent, right? And that's what the Supreme Court determined. No, you have to look at the document itself. That's all you can look at. You can't make any assumptions. You can't take any inferences. You have to look at the documentary evidence only. And with that, if there are no further questions, I'll rest.
Thank you,
Thank you,
Ms.
Your Honors.
Martin and Mr. Clements, for your arguments. We'll take your case under advisement. Call the next case, please.